Today, my Teach the Class video will be explaining misrepresentation and passing off with reference to Mars Australia Pty Ltd and Sweet Rewards Pty Ltd. As a tort, passing off protects the goodwill of the applicant by trying to stop another trader from linking their product to another trader's if it's likely to cause damage to the first business. Put simply, the classic trinity or three requirements of passing off are that the plaintiffs enjoy a certain reputational goodwill, a misrepresentation by the defendant, intentional or otherwise, and thirdly, that the plaintiff suffers or is likely to suffer damage. All of the elements are interrelated in a passing off case, and the existence of conduct which damages the applicant's goodwill by wrongly suggesting a connection between the respondent's wares and the applicant's will often also be misleading and deceptive. Proof of misrepresentation in passing off ultimately depends on the court's overall impression in the circumstances. Misrepresentation typically concerns the origin of the goods, involving a defendant misrepresenting that its goods are those of the plaintiff. In Mars Australia and Sweet Rewards, the applicant, who was Mars, the long-time manufacturer of Maltesers, brought proceedings against Sweet Rewards, the manufacturer of Malt Balls. There were three claims for passing off concerning: Number 1, the representations about source and origin. Number 2, product equivalence representation. And thirdly, whether every malt ball represents that it is a Malteser. The first claim is the classic form of passing off. In this case, it's necessary to identify the features of the applicant's packaging in which a reputation is said to inhere, as this is what the tort is protecting. Mars claimed the key features of their getup included the following, which you can see listed on the slide. However, the judge considered that the principal component in the Malteser's getup is in fact the word Maltesers, and that it is highly unlikely that any ordinary consumer of chocolate confectionery could mistake something which is not called a Malteser for a Malteser. In that sense, Mars is a victim of its own success. Hang on, what does he mean by that? Well, the other features relied on by Mars, namely the red colour and the pictures of the Malt Ball's product in the whole and cut through, are not distinguishing features of the Mars product and are commonplace in confectionery packaging. This is what the trial judge meant when he said Mars is a victim of its own success. The second and third passing off claims were held to be of no substance, as they also hinged on the court's finding the red and orange jars deceptively similar to the Malteser's getup. However, regarding the product equivalence claim, had the packaging in the first claim been found to be deceptively similar, the trial judge said he would be prepared to concede product equivalence. In his Honour's view, carrying the name Malt Balls and using slightly different visual features was sufficient to distinguish them from the Malteser's products. In fact, the wording Malt Balls extinguished entirely whatever limited confusion the floating balls might otherwise cause, such that one would know one is eating a malt ball and not a Malteser, in respect of the third claim that every malt ball represents that it is a Malteser. So to have passing off, you must have misrepresentation. In Mars Australia Pty Ltd and Sweet Rewards Pty Ltd, misrepresentation was not made out. Mars had become a victim of its own success. Misrepresentation is best characterized by a deceptive similarity. To paraphrase the trial judge, cases may well be imagined where two products might be deceptively similar because of the names used and the manner in which those names are presented. However, the present case is not one. Thank you for listening.